2:40 a.m. Eastern Daylight Saving Time 0240. What the High Court will tell us tomorrow. It usually takes months for the High Court to hand down a decision, but the result in this case has been expedited due, rather ironically given one of the main questions of law at play, to urgency. The Australian statistician, David Kalish, has given an undertaking to the court that ABS will not start the voluntary postal survey until midnight on the 11th of September, which gives the government 5 days to scramble if the High Court rules the survey itself, or the mechanism used to fund it, invalid. Conversely, if the court finds against the plaintiffs, marriage equality campaigners will have 5 days to ramp up their campaign activities in order to try to secure a yes majority. As Paul Kopp has reported, Tiernan Brady, director of the Equality Campaign, expects most people will return their postal survey form within the first 72 hours. What we can expect when the court returns at 2:15 p.m. tomorrow is an answer to each of the questions contained in the special case document, which asked do the plaintiffs have standing to appear in this matter. Was Finance Minister Matthias Cormann's direction for an additional $122 million to fund the survey valid under S.10 of the Appropriations Act? Was that expenditure within the definition of ordinary annual services of government, as set out in the Constitution, and is that question justiciable? Is asking the ABS to do this survey under the ordinary annual services of the ABS. If the answer to questions 2, 3, or 4 is yes, what should be done as relief? The plaintiffs are seeking injunctions to stop the survey. Who should pay costs? Solicitor General Stephen Donoghue told the court he only required an answer to question 5, which, as the court pointed out, is kind of cheating because answering question 5 will require the previous 4 to have been answered. There is no indication of which way the court will go, but the plaintiffs only need to have convinced 4 of the 7 judges of one of their arguments in order for the postal survey to be deemed invalid. On the other hand, Donoghue only needs 4 of the 7 to agree with his argument that the plaintiffs do not have standing to challenge this matter in the High Court, and the whole case will be thrown out in the government's favor. It does, however, appear unlikely that Donoghue's claim the survey will go ahead if only the funding is deemed invalid, and not the survey itself, will prove true. If they are successful on any count, Kate Richardson, counsel for Australian marriage equality, said, the relief they will seek is an injunction to stop the survey. You can read Melissa Davies' wrap of the day here. Updated at 2:46 a.m. Eastern Daylight Saving Time. Facebook, Twitter, Google+. 2:17 a.m. Eastern Daylight Saving Time. 0217 High Court to deliver its decision at 2:15 p.m. tomorrow. Facebook, Twitter, Google+. 2:14 a.m. Eastern Daylight Saving Time. 0214 Facebook, Twitter, Google+. 2:08 a.m. Eastern Daylight Saving Time. 0208 Melissa Davies. It appears increasingly unlikely the court will hand down its decision today. Court is set to adjourn at 4:15 p.m. Senior counsel for the plaintiffs, Kate Richardson, is currently rebutting some of the arguments put forward by government barrister Stephen Donoghue today. You can read a summary of those arguments here. But that doesn't mean we can't make some guesses of what might happen based on how things unfolded over the past couple of days. Lawyers representing the plaintiffs faced much more rigorous questioning from the bench. The judges seemed unconvinced by the argument that collecting opinions on same-sex marriage was any different to historical surveys that asked Australians for opinions on what Australia should look like as a nation. Kathleen Foley, junior counsel for Wilkie P. Flagg, and Felicity Marlowe, responded that those past surveys never asked Australians about their personal beliefs, prompting discussion whether opinion could be considered a statistic. Donoghue faced less questioning when he outlined the government's case on Wednesday. This doesn't necessarily mean the court is convinced, but suggests that they had fewer issues with his argument that the postal survey was both unforeseen and urgent, and therefore the $122 million allocated by the government outside of the budget towards the survey was necessary. It's safe to assume the Australian Bureau of Statistics would be confidently unpacking their envelopes and preparing to head to the post office. Facebook, Twitter, Google+. 2:03 a.m. Eastern Daylight Saving Time. 0203 Final stretch. Kate Richardson, counsel for Australian marriage equality, and Senator Janet Rice, is now on her feet and offering her reply to the government's arguments. She says that the phrase ordinary annual services of government, which is included in the long title of the Appropriations Act and, she argues, sets a constitutional limit on the provision of financial advances under Section 10 of the Act, exists independently of the legislative architecture and should be considered separately. She says the requirement that expenditure under the Act be for the ordinary annual services of government cannot be waved away. In defense of the argument that the minister did not satisfy the requirement under Section 10 for the expenditure to be unforeseen, Richardson said the specificity argument offered by Donoghue does not gel with past practice. Donoghue argued the postal vote was unforeseen because the involvement of the ABS, and the decision of the cabinet on the 7th of August, were not known by the finance minister before the budget was finalized. He said broad discussions about a postal plebiscite in March 2017 effectively did not count. Richardson: we say the advance is unavailable in those circumstances. And the reason is that information was in contemplation, it was being considered, so it is not unforeseen for the purposes of Section 10. Richardson said this requirement that the expenditure be unforeseen, what I'm going to call generally unforeseen as opposed to specifically unforeseen, is a safeguard in the Appropriations Act. She says Matthias Cormann admits in his affidavit that he was aware of the postal plebiscite conversations, which she said means it could not be considered unforeseen. In our submission, this is the easy case where the minister has given evidence that he knew. Updated at 2:07 a.m. Eastern Daylight Saving Time. Facebook, Twitter, Google+, 1:50 a.m. Eastern Daylight Saving Time. 0150 Melissa Davey at Melissa Davey. Another non-expert take from me as lawyers wrap up to their arguments. The House Bureau of Stats best have placed their bulk envelopes order SSM September 6, 2017. Facebook, Twitter, Google+, 1:44 a.m. Eastern Daylight Saving Time. 0144 Ron Merkel QC, counsel for Wilkie & Co., is speaking now in reply to the government's defense. He said the arguments used by the government against the standing of his clients used a subjective authority as if it were a hard rule. He also offers an alternative history of the Appropriations Act, saying there was an impermissible deliberation of power that totally removed the supervision of Parliament. Merkel argues that Donoghue, in rebutting his original argument that Matthias Cormann did not meet the urgency criteria in approving the funds for the postal vote, has not given enough weight to the word. When the current form of Section 10 of the Appropriations Act was introduced, urgency and the word urgent had a bigger role to play than the one my learned friend submits. He dismissed the argument that the same mechanism had been used to approve sports center upgrades or arts grants, saying the $122 million for the plebiscite was a different sort of thing to $3 million for some building works. We don't put that urgent is divorced from context or circumstances. From the small appropriation, it might be that would fall within a standing appropriation or a departmental spending. In contrast, he said, the postal survey is a dramatically new policy requiring a significant new expenditure. On the validity of the direction to the Australian Bureau of Statistics, Merkel says it is not the collection of opinion that is the problem, but rather the prescriptive nature of the government's instructions. If it were a true statistical exercise, the government would ask for information on a certain topic and the ABS would choose the sample, weighting and questions. In this case, there is to be no weighting and both the survey pool and questions are predetermined. Merkel: as we understand it, a direction of this kind has never been given before. Updated at 2:01 a.m. Eastern Daylight Saving Time. Facebook, Twitter, Google+, 1:27 a.m. Eastern Daylight Saving Time. 0127 Government case wrapped up. Donoghue has wrapped up his submissions by suggesting the court confine its response, given the urgency of the case, to answering question 5 in the special case document. That's a fairly tricky request, because question 5 contains within it the answers to the 3 previous questions. It reads 5. If the answer to question 2 or question 3, B or question 4, B is yes, what, if any, relief sought in the amended statement of claim should the plaintiffs be granted? The judges have sought to amend that question to cut out reference to earlier questions and just say what, if any, relief should be granted, stripped of legalese. That question asks should the ABS be able to go on with the survey. The government needs an answer to that question by Monday, because the ABS will start posting survey forms on Tuesday. Donoghue argued it is the central question because, as previously stated, finding the funding invalid does not itself stop the survey. In the event the court were to find that $122 million was unavailable, there would be a decision to be made by the government as to whether to revoke that direction. Otherwise, the duty would remain. Facebook, Twitter, Google+, 1:11 a.m. Eastern Daylight Saving Time. 0111 Donoghue is now focusing on the argument put by Wilkie's case, that the Australian Bureau of Statistics cannot undertake the postal survey because it is not, technically, a collection of statistical information. This means we are back to defining the meaning of statistics. Here's Donohue's definition: provided that the collection of opinions of a specified chosen population on a specified question can be counted, analyzed, and used to form fact, then it can be called statistical exercise. Basically, he says if you can count it, it's a statistic. He says that whether or not you are satisfied that it is an ordinary statistical exercise, it's certainly not a vote. It lacks many of the ordinary characteristics in Australia of a vote. In particular, it is voluntary, it is not taking place in person, and it lacks the ability to direct any particular outcome. That is a handily summary of the reasons why many who support marriage equality do not support the postal survey. On the argument raised yesterday that the ABS cannot collect opinions, Donohue says that conducting a survey to test the public's opinion on marriage equality is actually given as an example in a current statistics textbook. That is possibly an unflattering reflection on how long this debate has been going in Australia, because textbooks do not typically have a quick turnaround. Donohue says there is no legal argument against the involvement of the ABS. Updated at 1:23 a.m. Eastern Daylight Saving Time. Facebook, Twitter, Google+, 12:56 a.m. Eastern Daylight Saving Time. 0056. Updated at 1:03 a.m. Eastern Daylight Saving Time. Facebook, Twitter, Google+, 12:41 a.m. Eastern Daylight Saving Time. 0041. Paul Karp. In another dispatch from the National Press Club in Canberra, Tiernan Brady has rejected the suggestion that the High Court case has detracted from the Equality Campaign's ability to get out their yes vote in the postal survey. Explaining why it had taken the case to the High Court, he said Australia makes its decisions by Parliament. The rights and responsibilities of people, those decisions are taken in that building where the people elect 150 MPs to do just that. If you take one group of people in society, forget the words lesbian or gay, and say to them you have to reach a higher standard, a different process, before Parliament will even consider whether to treat you equally, I think that sends a dangerous precedent. Although the Equality Campaign had taken the case, it also has a duty to prepare for the campaign. I suppose, in answer to whether it is compromised, I would point to the enrollment campaign, which was the biggest single enrollment campaign since Federation, the AEC said, so over 1 million people added their names or updated their addresses. People know this is important. They are getting ready to stand up for their friends, neighbors and work colleagues. People understand we have had a nuanced journey to getting to do something very straightforward, and I don't think it's diminished our ability to campaign and persuade. Updated at 12:57 a.m. Eastern Daylight Saving Time. Facebook, Twitter, Google+, 12:31 a.m. Eastern Daylight Saving Time. 0031. Donohue has picked up his argument at the affidavit sworn by Finance Minister Matthias Cormann, which the plaintiffs argued indicated he had conflated unforeseen and urgent to mean expenditure for the postal survey was urgent because it was unforeseen. Donohue says he accepts that the language of that particular sentence does adopt what appears to be a shorthand link between the two terms. But on a fair reading of the document it doesn't disclose jurisdictional error. He now turns to the constitutional issue, which is whether the discretion to release funds under Section 10 of the Appropriation Act is limited to the ordinary annual services of government. The phrase ordinary annual services of government is contained in Sections 53 and 54 of the Constitution. He says the plaintiffs have applied this rule too narrowly, saying if one was to take ordinary services to mean something an agency had not done before, and run a finger down the list of agencies in Schedule 1 of the Appropriation Act, it would on that reading find a number of breaches. That would, we submit, require a level of judicial review of expenditure and appropriation of the kind we haven't seen before. Updated at 12:55 a.m. Eastern Daylight Saving Time. Facebook, Twitter, Google+, 12:09 a.m. Eastern Daylight Saving Time. 0009. Given the urgency of this matter, with the ABS hoping to start sending out postal surveys in 6 days' time, the High Court is expected to deliver its decision fairly rapidly. That could be as early as this afternoon, but I understand that those involved in the case think that is unlikely. More likely is a response sometime this week, with a meaty written judgment to follow. Tipping that slightly is the indication that we are likely to run up to the 4:15 p.m. finishing time, hearing Donohue's final arguments, which are expected to run for another hour, and the replies of the two lead counsels for the plaintiffs. But the court is likely to want to give a response as soon as it can, to allow the government to respond accordingly. Updated at 12:16 a.m. Eastern Daylight Saving Time. Facebook, Twitter, Google+, 11:38 p.m. Eastern Daylight Saving Time. 2338. What we heard this morning, Solicitor General Stephen Donohue will get to his final point rebutting the plaintiff's arguments at 2:15 p.m. He has already argued that the plaintiffs do not have standing to appear in the High Court. The arguments against the validity of the Australian Bureau of Statistics involvement should be struck out. The argument Section 10 of the Appropriations Act is in itself invalid, does not fit with either the legislative or practical history of the Act. The $122 million expense of funding the voluntary postal survey was urgent in the sense that it was an urgent need for funding to deliver a government policy. Providing funds to the ABS to run the survey was unforeseen because prior to the 7th of August there was no plan to involve the ABS. Both urgent and unforeseen are criteria that are open to ministerial discretion, despite counsel for Australian marriage equality, Kate Richardson, arguing that unforeseen was a jurisdictional fact. There is a high degree of specificity involved in a policy subject to an appropriation, so it cannot be argued that the finance minister foresaw the expense when the idea of a postal survey was first publicly discussed by ministers in March. Importantly, Donoghue began his address this morning by saying that even if the finance minister is found to have misinterpreted the law by accessing the $122 million without parliamentary approval, that would not necessarily knock the voluntary postal survey on its head. The ABS is conducting the voluntary postal survey in response to a directive from the Treasurer, Scott Morrison. The funds were allocated in response to a directive from the Finance Minister, Matthias Cormann. It is Cormann's directive, involving the access to public funds without parliamentary approval under S.10 of the Appropriations Act, that is subject to the substantive challenge. Invalidating one would not void the other, it would simply mean the ABS had to conduct the survey within its existing budget. That's super-duper bad news for the ABS, which is not exactly flush. The funding Cormann provided for the survey is about a third of that agency's annual budget. Updated at 11:54 p.m. Eastern Daylight Saving Time. Facebook, Twitter, Google+. 11:21 p.m. Eastern Daylight Saving Time. 2321. Paul Karp at the National Press Club in Canberra. The Equality Campaign Executive Director Tiernan Brady and Australian Marriage Equality Co-Chair Janine Middleton have vowed to continue the campaign whatever happens in the High Court or if the survey goes ahead and returns a no vote. Brady said the campaign has been overwhelmed by volunteers and they expected hundreds of thousands of supporters to make phone calls to family and friends urging a yes vote. The call for marriage equality grows and grows and grows, and this issue isn't going anywhere. Rather, the campaign will refocus on Parliament if the survey is struck down. Brady said it's not a matter of politics like tax or where to build a bridge, it's about people's dignity. Middleton says the issue is not like the Republic where, if supporters lose a referendum, they will go away and come back in 20 years. Rather, they will continue to fight. Updated at 11:55 p.m. Eastern Daylight Saving Time. Facebook, Twitter, Google+. 10:51 p.m. Eastern Daylight Saving Time. 2251. Now to the unforeseen argument, which the plaintiffs argued thusly: given that the Turnbull government has been talking about running a plebiscite on marriage equality since 2015, attempted to get the enabling legislation past the Senate in 2016, and had ministers publicly speculating about a possible postal survey in March 2017, the postal survey cannot be unforeseen. That argument was accompanied by references to Finance Minister Matthias Cormann's press releases of 8 and 9 August, which referred to the postal vote as a plebiscite and said it was delivering on the government's election commitment, indicating a continuation of policy. Donoghue argued that while all that might be true, the specifics of the proposal, both the involvement of the ABS and the decision of the 7th of August cabinet meeting, were unforeseen. He argued that the way the Appropriations Act was set out, where funding is allocated by an agency in Schedule 1, the government could not allocate funds for an unformed plan to conduct some kind of postal plebiscite, and said it would be unreasonable to allocate funds based on speculative possibility. Donoghue because Schedule 1 is listed by entity, the foresight is therefore linked to the entity. That would be a most surprising, to say the least, approach to government appropriations, to appropriate hundreds of millions of dollars at least on a speculative possibility. With that, court has risen for the lunch break. It will resume at 2:15 p.m. Updated at 10:55 p.m. Eastern Daylight Saving Time. Facebook, Twitter, Google+.